Hello there and welcome to Sheria Briefs. This is where we make the law practical. It's really a pleasure to be back. We were on a short break, but we are back today. And today, my friends, I tell you, we are going to discuss something that I'm sure at the end of this episode, you will have a lot to really think about. So if you watched our last episode, and if you didn't, you better, because we talked about customary marriages in our last episode, and we were just facing the realities here in Kenya, that most people are in marriage settings where they have probably just done rorashio, or they have performed some customary rites, but they've not registered their marriages. And we highlighted the problems that come with that. So today, we are building up on that. And we are going to focus on what in law we call the doctrine of presumption of marriage. Don't worry, I don't even feel like I'm already getting started on jargon. No, I will break it down. Basically, the question I am asking you today, and which I want you to consider is, does it mean that if there is no wedding, there is no certificate, there is no problem? That is the question. What do you think? So you better stay tuned, because that's what we are going to discuss today. So I want to break it down and show you the history of where we have come in terms of the legal process. Because this is a reality that is with us today, that you find people have been living together for 20 years. They have 5 children. Everybody knows them as husband and wife. So are those people legally married? They don't have a certificate. There was no wedding. But is that a real marriage? That is what we're talking about today. In law, there's something that came up in the early 70s, known as the doctrine of presumption of marriage. By that, we simply mean it is a doctrine that, if properly applied, will lead to the presumption that there is an actual marriage, looking at the circumstances of a particular scenario. All right? So presumption to mean presuming that there's a marriage between this man and this woman. All right? So how did this whole thing begin? Like I said, we have many people. And our parents, in fact, I'm a millennial myself. Most of our parents fall in this category, where everybody knows them as husband and wife, but there's no church wedding really, there's no certificate, there's nothing. But everybody, there's no question that this man and this woman, they're husband and wife. So let me take you down. What I will be doing today is breaking down this conversation through the lens of court cases. Okay? This is so that you can have a very clear understanding of varied scenarios, very different situations, and see what happened in this case. What did the court say? And how does that apply to you? Why? Because those particular instances actually characterize most of the situations out here. All right, so I will start with a case known as Hortensiah Yawe versus the public trustee. This is a case that goes back to 1976. For our purposes, just know it as the case of Hortensiah Yawe. It's a 1976 case. And this is the first case, as far as we know, that affirmed, if you will, and recognized this doctrine and made it a formal way of recognizing marriages in Kenya. So basically, in this case, we had a situation where Hortensiah was married to a man known as Paul, and Paul was a pilot with the East African Airways. He was Ugandan, Paul was Ugandan, but Hortensiah was Kikuyu and Kenyan. So they used to live here in Kenya, in Nairobi, and unfortunately, Paul got involved in a road accident sometime in 1972. So when Paul died, Hortensiah went to the public trustee. We have the system of, as an institution known as the public trustee, which also deals with succession matters where these things don't go to court, okay? So Hortensiah went to the public trustee wanting to be recognized as a widow of Paul so that she could, of course, inherit from his estate. So at the public trustee level, the parents of Paul, the mother specifically, and his siblings, all said, no, we don't know Hortensiah. Yeah, we know her. I mean, we've seen her, but she's not a married. She's not a wife. She was not, never a wife to Paul. Why? Because according to them, there was no valid customary marriage that had happened between Paul and Hortensiah. So, of course, because the dispute escalated like that, it was referred to court. And now at the High Court level, the main question became, looking at the circumstances of that situation, was Hortensiah Paul's wife? Remember, they had 4 children. These are now the things that the court was looking at. These 2 people had 4 children. They had lived together for over 9 years, well over 9 years, all right? Paul had taken Hortensiah to his mother, not once or twice, and told the mother, this is actually the mother of my children. In fact, now this is even the most interesting part. In his application documents, I told you Paul was a pilot with the East African Airways. In his application documents, he had listed Hortensiah as his wife, okay? We got that? So now we're in court, and we are asking whether Hortensiah should be recognized as Paul's widow for purposes of succession. The High Court looked at the evidence, and the High Court was like, no, Hortensiah cannot be recognized as a wife because the marriage, that the customary things that happened in their situation were not completed. So the court was like, this was not a valid customary marriage, and therefore we cannot recognize Hortensiah as a wife for purposes of succession. Of course, the kids, it was a different story. The children, those 4 children, the court was like, yeah, these are children, they are legitimate children, and I mean, in our next episode, we'll talk more about children and, succession things, but the law recognizes children regardless of whether people are married or not. So the court said the children can and should inherit, but Hortensiah herself is not a wife for purposes of this succession dispute. So of course, Hortensiah was not satisfied with that finding, and she appealed. She went to the Court of Appeal. So at the Court of Appeal, the court looked at all these circumstances, and the court disagreed with the High Court. The Court of Appeal was like, no. In this scenario, these people have lived together for 9 years, plus they had 4 children. In all circumstances, everybody knew Hortensiah as Paul's wife. Remember, I told you, even in his own application documents, when he was looking for employment at the East African Airways, he listed Hortensiah as his wife. So the Court of Appeal said, by all means, Hortensiah and Paul had a union that could safely be regarded as a marriage. Okay? So it is at that level, that was the first time in Kenya's legal history where it was formally recognized that you can be presumed to be husband and wife if you can show that you people have lived together as husband and wife for a long period of time. You have, if God has blessed you to have children, the better. It goes towards that and it establishes that you have carried yourselves out there in a manner that if we call anyone who knows you, they will say, I know this and this person, a husband and wife. In terms of your public reputation, you have presented yourselves as husband and wife to the general public, all right? So at that level, the court established now what has been known as the doctrine of presumption of marriage. You're with me? So it started in 1976. But now as time went by, and that's the whole point of our discussion today, to just show you how this thing has evolved and how it has remained flexible and how, as we speak today, it can actually be something that is very, very difficult to rely on. So we are now post-1976, now it has become legally recognized and people are going to court for purposes of succession and they're saying, we were married, we can prove it, we have children, so-and-so knows us, and all of that. Fast forward, we are now in 1985. So in 1985, something again significant happened and it shifted things in a very interesting sense. So in 1985, a case was filed, and this case is known as the case of Mary Njoki versus John Kenyan, 1985. But for our purposes, just for your own remembrance, let's call it the case of Mary Njoki. Tulianza na the case of Hortensiah Yawe. Now it's 1985, we are looking at the case of Mary Njoki. So what happened with Mary Njoki? So again, Mary Njoki was dating, in fact, a wakili like me. Mary Njoki was dating a wakili. They started living together. This was between 1969 to around 1975. They lived together for approximately 7 years. Mary Njoki was known to this wakili's friends as the person he lives with. In fact, even the wakili's parents and relatives had known her. They had seen her. They lived together in a house, I think in Langata. Then, unfortunately, this wakili again got involved in a road accident and he passed away. So, of course, succession, followed. Everybody on the other side, meaning the wakili's family and relatives, they were like, no, we do not know Mary Njoki. She cannot be considered to be Paul's wife. Why? Because there was no marriage whatsoever, not a customary marriage, no ratio has happened. They didn't even have children. By the way, these guys, there was no children. So they disputed Mary Njoki's status as a widow of the wakili. But Mary Njoki rebutted, and she was like, no. I lived with this wakili for from 1969 to around 1975. Those are 6 years. Yes, we did not have children, but the wakili had actually expressed a formal intention to marry me. He had told me he would marry me. His partner, his own law partner, this wakili had a partner in his law firm, knows me or knew me as the wakili's wife. In fact, even my own father has known the wakili. I have introduced him to my family as my husband. So you cannot now come and say that he was not my husband. He was. So at that high court level, the judge looked at everything that had been presented before him, and he was not convinced that Mary and this wakili had a relationship that could be safely presumed to be a marriage. Okay? The judge was like, the arrangement you guys had, it was not real cohabitation in that sense, and therefore you are not a widow, you're not the wakili's widow for purposes of succession. So of course at that level, Mary was dissatisfied, and of course she appealed. She went to the Court of Appeal. So now at the Court of Appeal is where things happened in a very interesting sense. You see, the Court of Appeal sits in benches, to mean that it's usually more than one judge that hears and determines cases in most cases. So in this particular situation, there were 3 judges that sat on appeal to listen to Mary Njoki's appeal. When they reviewed the evidence that I've just, the facts and those issues that I've just broken down for you, one judge decided that he was convinced that indeed there was a marriage. One judge was like, these people had lived together for 6 years. In fact, part of the witnesses that came at the High Court level include the wakili's partner that I mentioned, who came and testified that we knew Mary Njoki, So one judge at the Court of Appeal disagreed with the High Court and said, according to him, indeed there was a marriage. They had lived in a situation, or looking at the circumstances, it could be safely be presumed that there was a marriage between Mary Njoki and the wakili. But these 2 other judges disagreed. These 2 other judges looked at the evidence again, and they were not convinced that what Mary Njoki and the wakili had crystallized into a marriage. In fact, one particular judge, one of those 2 that were now disagreeing that there was a marriage, said, looking at the evidence before them, what can be seen is that Mary Njoki and the wakili had a very close friendship. In fact, a particular judge known as Nyarangi J rather coined this phrase, concubinage. Concubinage, to mean Mary Njoki could not be considered to be anything more than a mere concubine or a mere close friend to the wakili. So according to these 2 judges, they set a different level, or they took this doctrine of presumption of marriage to a different level. They said, well and good, you might have cohabited. Well and good, you might have been, portraying yourselves out here as husband and wife. But if we cannot find the intention, if we cannot ascertain that there had been an intention that you people be married, then we will not apply this doctrine in your favor. You will not be allowed to rely on this doctrine. So what came out of this case, and what is very critical for your understanding, was that mere close friendship, mere concubinage, as it were, cannot amount to a safe presumption of marriage. It cannot. If you're just close with someone, and most people in those kinds of relationships, you've lived with someone for really long, years on end, but in all honesty, no one can actually safely claim that they intend to marry you, not even you yourself. Ukiulizwa kweli kweli mnaoana, you cannot answer that question definitively. Then yours would be what we are talking about now. it would be inferred or referred to as mere concubinage or just a mere close friendship, unfortunately. So Mary lost it because at the Court of Appeal, the majority wins. So because 2 out of 3 were of the view that whatever she had with the wakili could not be called a marriage, of course she lost the case. But what is the significance of this case? Now the significance of the case of Mary Njoki is that it really affirmed the doctrine of the presumption of marriage, that indeed, if you are known for, living together for a long period of time, you have carried yourselves out here as husband and wife, you have children, you have even invested in property together, yes, that could lead to, the doctrine being applied in your favor. But what it did is that it set a caveat, if you will. It provided a caution that not just any manner of cohabitation will be taken to be marriage. No. That there has to be an intention. And it must be evident and ascertainable that these people had intended to be husband and wife. You're with me? Great. So we move on to case number 3. We started with Hortensiah Yawe. We moved to Mary Njoki, and I've shown you how Mary Njoki set boundaries. That you not just come and say, I've been living with this person. No. It is not just a matter of living together or even being known by other people as husband and wife. No. But now moving on to case number 3. Hapa mambo sasa ikaanza kuchemka. So case number 3, it was between a lady called Phyllis Njoki versus Rosemary Mweni. So for our purposes again, let's just call it the case of Phyllis Njoki. Now, this Phyllis Njoki case was a 2009 case. So we started in 1976, moved to 1985, now we are in 2009, and these are just the major cases. Of course, in between, a lot more other cases happened. But for our discussions today, let's now look at this case of 2009, and I'll tell you why it was significant. So in this particular case of Phyllis Njoki, what happened is that there was a man here known as Karanja. Karanja got married to a woman known as Margaret. Now, Karanja and Margaret got married under Kikuyu customary law. They ratio. They performed all the cultural rites that come with the Kikuyu, customary marriage, so to speak. So it was not even in dispute that Karanja had been married to Margaret, all right? Karanja unfortunately passed away. So by the time Karanja was dying, Margaret was recognized as Karanja's wife. They had done all, that needed to be done to be husband. They had children and all of that. But then, during the succession proceedings, as you know, with our Kenyan things, you have seen this. People just come up. People just show up. So what happened? After Karanja was buried, a lady known as Rosemary showed up. And she said, I am also a wife. I have a child with Karanja. We have lived together with Karanja for about 6 years. In fact, at some point, Rosemary was even housed by Margaret, the first wife. You're with me? Because this was a polygamous setting, loosely speaking, at some point she was even, housed by Margaret, the first wife. Of course, everybody in Karanja's family had regarded her as a second wife. To who? To Karanja. So the question became, can she be considered a widow or a wife for purposes of succession? Of course, Margaret said no. Of course, Karanja's family said no. The High Court looked at all the evidence that was before it in terms of, what had happened, how she had participated and all of that, and the relationship that Rosemary had with Karanja. And the court said, looking at this scenario, we think that, yes, the court established that Rosemary was a wife for purposes of succession. So the bigger question was, remember, I've told you, Margaret was the first wife. She had been properly married under Kikuyu customary law. But here, the court is affirming Rosemary also as a wife because of this doctrine of presumption of marriage. So the High Court was convinced and satisfied that Rosemary had proved that the circumstances between, characterizing her union and Karanja led or meant that this doctrine should be applied in her favor. Of course, The family of Karanja was not happy with the High Court's decision, so they appealed to the Court of Appeal. So now at the Court of Appeal, the bigger question was this, all right? And this is now what marks this case as setting another bar or another level compared to the first two cases that we have discussed. So at this Court of Appeal level, the bigger question was, can Rosemary be safely regarded as a wife even where no customary marriage rites have been performed? Remember, it is not in dispute that Karanja had a first wife, who is Margaret, and who was married for all intents and purposes rightly under Kikuyu customary law. But Rosemary isn't. The Court of Appeal looked at the circumstances again in this case, and they concluded that, number one, yes, Rosemary had established the circumstances that lead to a presumption of marriage. She had established long periods of cohabitation with Karanja. They had a child together with Karanja. As I've told you, at some point, Rosemary was even housed by Margaret, you know. The family of Karanja, even his own brothers, had recognized Rosemary as a second wife, okay? So the court looked at all of that. And, before I forget, during the burial arrangements for Karanja, Rosemary participated. She was there all through. So the Court of Appeal was convinced that, this woman, for all intents and purposes, had a relationship that could be safely regarded as a marriage with this Karanja man. But the bigger question, or the bigger issue for our purposes here, is that the court looked at whether Karanja had actually the capacity to marry a second wife. Are you with me? So the first case, and I'll now just summarize it so that we are together. The first case of Hortensiah Yawe recognized and formally established the doctrine of presumption of marriage. Okay? Our second case of Mary Njoki came and set boundaries and said, you can't just come and say, we've lived together for 7 years. No. There has to be intention, and it has to be ascertainable. Now we're on the third level, where this case of Phyllis Njoki Karanja, the court is saying, all right, you have shown us that the box check in terms of the doctrine of presumption of marriage, but there's one more question. There's an additional thing that we have to consider. Did Karanja have the capacity to marry Rosemary? And that's a very important question. Why? Because, remember, I've told you Karanja was already married. So it became a very serious concern whether he actually had the capacity to marry someone else. And shortly I will explain why it is such a serious issue, especially now in 2026, this year of our Lord 2026. The court said yes, Karanja had the capacity to marry a second wife. Why? Because Kikuyu customary law, as far as marriage is concerned, leaves it to be a polygamous or a potentially polygamous union or situation. Meaning that today, if you're married under Kikuyu customary law acknowledges or recognizes that a man can have more than one wife. So if you're married under Kikuyu customary law, even if you're the only wife, please know that your husband can actually marry a second, a third, and I don't know up to how many wives. But that Kikuyu customary law recognizes additional wives. So because of that, it meant that Karanja had the capacity to marry. And in as much as there was no formal wedding ceremony or performance of customary rituals to signify his union with Rosemary, simply because Rosemary could establish that, these circumstances that lead to presumption of marriage could be safely applied in her favor, the court acknowledged that yes, Karanja had the capacity to marry. And now, as we move on to my last case for today's episode, sasa hapa ndio mambo inachemuka, boil over completely. You will understand, if you've been following very closely, you will understand why this issue of capacity became a very serious issue. All right, so now we are wrapping up on this last case. Now, this one, you better really listen closely, because the things that happened here, they really should be in a book somewhere. They should be written. It was a story and a half. So what happened here? This is a case between a lady known as MNK and a gentleman known as POM. So because of privacy issues and how, matrimonial disputes have evolved, courts usually protect the privacy of the parties. And even for our purposes, I will not reveal or disclose their full names. The case itself ended up to the Supreme Court in 2023, and it became known as the case of M&K versus POM 2023. All right? But this case began as a dispute in 2013. All right? And in this case, the differentiating factor is that no one had died here. It was not a succession issue. It started as a matrimonial property dispute. Okay? So what happened? So M&K, the lady, met this guy known as POM sometime in the 80s. They became friends. They started living together, I think around 1986. And they lived together until, I think, 2011. During this entire period of living together, they didn't have children as such, but they acquired property and they built on that property, rentals, and basically they were investing together. That's the point. So when things went south in 2011, this lady, Mary was in our previous case, pardon me. This lady, known as M&K, what did she do? She evicted the guy from the property that they had been living and investing in together, and decided that from now on, it's my property, Jipange. What did the gentleman do? Of course, he was very aggrieved. So he went to the High Court, and he went to seek distribution of the property that they had jointly acquired and developed. So now at the High Court level, this man sought distribution of that property, and this law is no longer operational. It got repealed. But that act was known as the Married Women's Property Act. So what that law provided for in broad terms was that now you could approach a court for division of what could be regarded as matrimonial property. Matrimonial property is property that has been acquired during a marriage. You with me? So this man, POM, went to the High Court to seek what? Distribution or division, if you will, of matrimonial property, claiming that my wife, my ex-wife, this lady M&K, has this property that amekwamilia, and in all fairness, it has to be distributed equally between the two of us. What happened here? M&K, the lady, said, no, I don't know this man. He is not and was not and has never been my husband. Why? By the time I started living with this man around 1986, I was previously married. I was previously married to another man known as KM. Okay? So M&K is saying that actually, by the time I was living or starting to live with this person who has brought me to court, I was married customarily. She had undergone customary rites in Kikuyu customary law and was properly married to another person known as KM. In fact, they had had children with KM, 3 children, who by the time now she was starting to live with POM, she came to POM with these 3 children. So Mary disputed, I don't know why I keep calling her Mary. M&K disputed the claim that she was married to POM, and she said, no, I was not married. In fact, hapa ndio mambo sasa inachemka. As part of her evidence at the High Court, she even produced her ID. Her ID bore her surname, a surname that the court was convinced, the High Court was convinced that that surname belonged to her previous husband, KM. All right? You know how even my mother, for example, I don't know about you, but most of our parents, or even some women today, adopt the names of their husbands as their surnames, and they put that on their ID, right? Or other official documents. So this lady, M&K, came to the High Court and said, to prove that I was never married to this man, look, even my ID still bears the name of KM. All right? At this point, KM was unfortunately deceased. He had already died. He died, I think, sometime in 2011. So this judge looked at everything before him, and he was convinced that the lady actually never got married to POM. Okay? But look, they had acquired property together. And this property was actually registered in the name of the lady, in the name of M&K. POM explained to the court, and he said, look, judge, the reason why this property is in her name only is because I am Kisi. And by the time we started living together, because this property is in a largely Kikuyu dominant locality, the person who I was buying the property from could not agree to sell it to a non-Kikuyu. So because of that, we agreed that, okay, let the property be registered in your name. Okay? But this lady is saying, that is not the story. This is my investment. I'm the one who paid for it. I'm the one who has invested in it. I'm the one who has done everything. So there's no way this man will come and now try to claim half of it. Are you following? Are you following? Mambo inachemka. The judge looked at everything before him and he was convinced that if anything, the relationship between M and K, the lady, and POM, the man, could be at best an adulterous relationship. Imagine. So the judge was like, you guys have been just living in adultery. This lady had no capacity to be married by anybody else. You remember, we've just discussed the concept of capacity. So the judge is saying the reason why MNK, the lady, had no capacity to be married to another person is because she was married to KM customarily, and they had done all those rituals by the time she was starting to live with this man. It's only that things didn't work out between her and KM, but they never dissolved that marriage. So by the time she was starting to live with POM, that marriage was still very much alive and well, and it was not dissolved. And therefore, in Kenya, we don't recognize polyandry. Do you know what polyandry is? Polyandry is a situation where one woman is married to more than one person, more than one man, to be sure. So in Kenya, we don't have that. What we have is polygamy, where men can marry more than one woman or wives, for that matter. So the court was like, no, in Kenya, we don't have polyandry, and therefore, at best, this can only be described as an adulterous relationship. So what did the judge do? The judge dismissed the man's, claim, and basically did nothing even about the property. Of course, POM was aggrieved, so he rushed to the Court of Appeal. And he laid everything that I've just said before the Court of Appeal. And he said, how could the judge not see that a marriage had crystallized here? We have lived together. Remember, by the way, that first case, you remember we discussed the one for Hortensiah Yawe. Those guys had lived for, I think, a little over 9 years. Here, we are talking about people who had lived together from 1986 to 2011. Do your math. That is well over 15, almost, I think, it's more than 15 years, right? So, how come in this situation the court is not able to presume a marriage between MNK and POM? Now we are at the Court of Appeal. The Court of Appeal looks at all of those things I've already described, and the Court of Appeal is furious at the High Court. The Court of Appeal is like, this is a classic case where the presumption of marriage doctrine applies. Oh, of course, there was a marriage between MNK and POM. And the Court of Appeal was not convinced of the evidence. You see these things that the lady was saying, you see, I was married to KM, Asijui, even the name on my ID is that person's name. Now, the Court of Appeal was not convinced about that. The Court of Appeal felt that the judge at the High Court placed undue weight on these things, on this evidence of the name, when it did not lead to much. So the Court of Appeal put a tick on the doctrine of presumption of marriage and said, you as the man, you are entitled to half share of that property. And the Court of Appeal divided the property into two, said, MNK, you will take one half, POM, you will take one half. This lady could not take it. So, she was like, no. This is my sweat. I have worked so hard for this. This man is not entitled to anything. So what happened? She went to the Supreme Court. So again, as a matter of caution, I'll just put a rider here. Not all cases go to the Supreme Court, by the way. Most of you know the Supreme Court perhaps maybe just for presidential elections. But the Supreme Court has the jurisdiction or the mandate to hear and determine cases which can be, loosely speaking, be regarded to be of very serious general public importance. Meaning that a case, it might look like an ordinary issue, but if we can ascertain that this thing is cross-cutting and it affects a lot of citizens in this country, then it can be certified either by the Court of Appeal or the Supreme Court itself to be a matter of general public importance deserving to be heard and determined by the Supreme Court. So MNK, the lady, of course aggrieved by the Court of Appeal's decision, did what? She applied to the Court of Appeal that this case be certified so that it goes to the Supreme Court. The Court of Appeal was like, no, there's nothing new here. There's nothing that deserves, the attention of the Supreme Court. So no, we are not certifying this matter. So she went to the Supreme Court itself to seek certification. The Supreme Court looked at everything, and the Supreme Court was like, hapa kumechemka. We need to hear this case. So the Supreme Court certified the case and had it. Sasa hapa ndo mambo ilichemka. So the Supreme Court, of course, the Supreme Court reviewed all the evidence, and the main question was, can we actually say that looking at the relationship between these people, a presumption of marriage had arisen? That was the main question of the Supreme Court. And of course, the other question, which in my opinion was not very, significant, but of course also very important, was whether now this man could rely on that law that I've just said was repealed, the Married Women's Property Act, to claim a share in this property. Now, the Supreme Court looked at all the evidence, and it was convinced, just like the High Court, that, number one, MNK was married to this other man known as KM before she started living with POM. The Supreme Court was convinced. The Supreme Court looked at the evidence, those stories of the ID and the names in the ID, and the Supreme Court was convinced that by the time MNK started to live with the POM, her marriage to KM had not been dissolved. Okay? So that this entire period she was living with POM, she was for all intents and purposes still married to KM. So for that reason, the Supreme Court was convinced that MNK, the lady, had no capacity. You remember capacity? She had no capacity to get married to this man known as POM. And because she had no capacity, therefore this doctrine of presumption of marriage could not apply. Even if all the boxes tick, even if you had children, even if you had bought property together, even if everybody in the world knows that you are husband and wife, even if you have listed that person as your, next of kin and spouse in all official documents, but you had no capacity to marry that person, this doctrine cannot help you. And why did this woman lack capacity? Because in Kenya, the system of polyandry is not recognized. We don't have situations where one woman can be married to more than one man. We don't allow that in this country. So definitely, until her marriage to KM could be dissolved, MNK would never have the capacity to remarry. So MNK wins on that front. And the court says, we need to set the record straight, because it looks like people are not clear whether this doctrine of the presumption of marriage is still alive and well, and to what extent. So now, I will quickly take you through very deciding or determining factors, that the court pronounced itself on, the Supreme Court. Number one, the court affirmed once again that the doctrine of presumption of marriage is alive and well. But, this is the interesting thing, the court said this doctrine is now on its deathbed. It's really dying. It's iko kwa lala salama, if you will. Why? Because now, as we speak in 2026, this case was decided in 2023, we have a Marriage Act of 2014 that clearly describes or stipulates the kinds of marriages that we have in this country. There are 5. We have a Christian marriage, a Hindu marriage, a Muslim marriage, a customary marriage, and a civil marriage. We have 5 types of marriages. And what this act did, while it kind of, described the types of marriages that we have under Kenyan law, this act, the Marriage Act of 2014, did not talk about this doctrine of presumption of marriage. In fact, for your information, if you are not aware, the Marriage Act of 2014, all it does is that it defines cohabitation. It defines cohabitation to be the, where two adults or it actually calls them an unmarried couple. It defines cohabitation as a situation where an unmarried couple lives together for a long period of time in a manner that resembles, that is the word used, resembles a marriage. But it does not validate the doctrine of, presumption of marriage. Neither does it say that now this doctrine is inapplicable. It is quiet, it is silent on the doctrine of presumption of marriage. So the Supreme Court thought it fit to set the record straight. The Supreme Court said, now we have a Marriage Act. This Marriage Act is silent on this doctrine. But let's assure you that this doctrine is not a type of marriage. I've told you we have only 5 types of marriages in Kenya. We don't have a marriage known as presumption of marriage. No, we don't have that. So basically what the court was saying, the Supreme Court is saying, is that if your situation does not fall within these 5 types of marriages, you can rely on this doctrine to prove that what you had should be considered as a marriage. Are you with me? But the court says because of the advancements we have had, this doctrine should be applied very exceptionally. It should be applied kidogo sana. Only in situations where we really need to apply them. Why? Because the Marriage Act of 2014 now requires, even if you are married under the customary law, you have an obligation to register your marriage. So if you don't have a certificate and you've not registered your marriage, it is only to your undoing. It is only to your detriment, because now the bar is getting higher and higher to prove that what you had should be presumed to be a marriage. That's number 1. Number 2, the court said that capacity to marry is essential. And I've just told you that this lady, the reason why the High Court and now the Supreme Court decided that what she had with POM could not be considered as a marriage, regardless of the number of years and the investments they'd had, it was because this lady had no capacity to get married to anybody else. For as long as her marriage with KM subsisted and was not dissolved, she had no capacity to marry anybody else. What am I saying? I am saying that even if today, and let me now bring this closer home, we have scenarios where I know of people who, for example, your marriage is not working or it has not worked, and you even got married in church or through the AG, that's the civil marriage. You have a certificate, okay? But things fail to work. So everybody goes their separate ways. And you live apart for 14 years even, 15 to 20 years. You've lived apart with this person. So that, in fact, we all know out here that, for example, X is actually divorced. But X has never gone to court to divorce formally and officially. If today X gets into another marriage, loosely speaking, let me put it this way. If today X starts living with Irene, okay? Today X brings me to their house and we start living together. And we live together for 10 years and we have children. And then a dispute arises. You know, whatever we've had with X for these 10 years will not be a marriage. And it will not be considered to be a marriage. And it cannot be presumed to be a marriage. Why? Because X had no capacity to marry me. Especially if it was a civil marriage. Why? Because a civil marriage is considered to be monogamous in Kenya. A civil marriage ya AG, that one is a monogamous marriage. Once you get married under that system of law, you cannot marry someone else until you first dissolve that marriage. Same goes with a Christian marriage. It is monogamous. The only thing that is potentially polygamous for our purposes is a customary marriage. So someone who's married in the customary law today, all they have done is ratio, and they have registered their marriage at the AG. That person can marry someone else, all right? So the court was affirming that capacity remains an essential tool. So this doctrine will not help you if the person you're living with, that person had no capacity to marry, or if you yourself had no capacity to be married. Now, the court set an 8-tier test, if you will, where now it set it sort of put guidance so that now courts below, Supreme Court is our highest court in the land, so that courts below it can follow this whenever a question arises as to whether a marriage can be presumed between party A and party B. Number 1, the court said the parties must have lived together for a long period of time. Of course, here it's open to interpretation. Long is subjective. I told you in Hortensiah, it was 9 years. In Njoki, it was around 6 years. In the next one, it was about 15 or so years. And in this particular case, it was even more than that. So what qualifies as a long period of time really is left to the court to interpret. Number 2, the Supreme Court said the parties must have the legal right or capacity to marry. So the Supreme Court cast it in stone that you will not come here and try to rely on that doctrine if you yourself or the person you purported to live with had no capacity to marry. Number 3, the court said these parties must have intended to marry. You remember the Njoki one? The Wakili one, where the court said, you people, what you had was just a mere close friendship. It has to be demonstrated that there was intention with certainty to marry each other. Number 4, it has to be shown that there was consent from both sides to live together and to marry each other. Okay? So it is not just a walk in the park. It's not. Number 5, it has to be shown that the both of you held yourselves out there as husband and wife. You held yourselves out there as a couple. That has to be established. And that has been there, of course, from the beginning. So it's not new. Number 7, the court said the burden of proving that a marriage should be presumed is on the person who claims there was a marriage. So if today I'm the one claiming I was married to X, the burden is on me to prove these things that I'm just listing here, to prove them to the satisfaction that is, of the court, that the marriage, that this is what happened, so a marriage should be presumed between me and that person. Number 7 or 8, I think I'm on number 7 now. The court said that if anyone is disputing that there was a marriage between X and Y, the burden now is on them to challenge the evidence that has been brought before the courts. For example, like I was saying in those previous cases, in Hortensiah and Njoki, the burden rests with the person who is disputing. Once you have established, for example, if I establish that we should be presumed to be married or to be in a marriage with X, then the person who refutes that, the person who is opposing that, now it is on them to prove otherwise. All right? And finally, the court said that this standard of proving these things is on what we call a standard, or a balance of probabilities. This is legal jargon, but basically it is to say it is not that high. You see, in criminal cases, we have a standard we call beyond reasonable doubt, and I'm sure you know about that. Now, in civil cases like these scenarios, it's lower than that, and we call it a balance of probabilities. That looking at these two stories, is it more believable that they were actually married or not? That's what we call a balance of probabilities. Now, something interesting happened at the Supreme Court as I bring this to a wrap. You see, there's the question of property. I've already told you that the Supreme Court found that no marriage can be presumed or could be presumed between M and K and POM. So the question was, so what do we do to the property? Is it fair that this man should just walk away empty-handed after all those years of working together and, sweating over this thing? It's not fair, right? You agree with me? It's not fair. But these people are not a couple. So what do we do? How do we distribute this property? Okay? So the court looked at the scenario and said, because we can't treat them as a couple, we will treat them under the law that applies to kawaida property. So we'll just treat them, say, okay, for our purposes, let me just use as business partners. We'll just treat them like that and see what did you contribute and what did you contribute. And then we will divide or distribute that property based on, the effort and the contribution you made towards the property. So that's precisely what happened. The court looked at all the circumstances in terms of the investments that this man had put in the property, and the court, in its own wisdom, arrived at a 70-30 distribution. So the woman got 70%, and this man walked away with 30% of that investment. But one thing that I want to leave with you, which is now closes for us very nicely, the court reflected. The court reflected. And the court thought, in Kenya today, and I'm sure you'll agree with me, we have so many scenarios. Perhaps you are watching me and your scenario is very, very close to this one of M&K and POM. You left a marriage somewhere. You are in this new relationship. Or you might not even have been previously married, but you're living with someone today, and you know that honestly you don't want to marry them. You don't want to be bound in a marriage relationship. So the court reflected. And the court was like, in places like Canada, by the way, I even learned through this case. In Canada, they have a law called the Adult Interdependent Relationships Act, which recognizes relationships like this, that there are people who are not married, all they want is to cohabit with each other and to, just live together without the intention of ever being married, as we know marriage to be. So how do we protect these people when things like this happen? What do we do with these people when things go south and they have to separate? What do we do with their property? What do we do with their rights and obligations? Canada now, wamefika hapo. So the Supreme Court was reflecting and was asking, have we as a country reached there? Do you think we have reached there? Please comment down there. Do you think as a country, tumefika mahali where we now need a law to regulate these kinds of relationships that are not marriage, they are just somewhere in between? Yeah? And I think personally, if you ask me, the reason why most people who are cohabiting are hesitant to officiate or formalize their unions, perhaps it's because this is what they prefer. And maybe it's time that we, consider that now. So the Supreme Court ended up by saying, let courts not impose marriage on people. People nowadays are living in situations where they don't want to be married. All they want is companionship, investment, or partnership, whatever else, but just not marriage. Don't impose marriage on these people. All right? So as we bring it to a wrap, as I close, I am asking you today, so do you think that if there's no wedding, there is no certificate, there is no problem? No, from what we've discussed, there actually could be a problem. Now, comment down there below. I would want to hear your thoughts on this. If you're in a situation like what we've been talking about, tell me, do you intend to formalize your union or not? And if not, why? But remember, if you don't intend to formalize it, then you have seen, I've just walked you through different scenarios of what might befall you if things go south, God forbid. But in our next episode, you better stay tuned, because in our next episode, we will take it to the next level as we finish this series. We will take it to the next level and look at now what happens in succession now itself. We have discussed what happens in terms of presuming marriage, but now at the succession level, what happens? And all of this we have discussed just to show you that it matters. It matters at the point of distributing property. If at all things go south, it matters in succession proceedings. And that is precisely what we'll be talking about in our next episode. So be sure to watch it. Thank you so much for being with me today. I really want to hear your thoughts on this. Let me know, do you think we should now start to mobilize Parliament to go the Canada way? Go and look out at your own time. Let's see what Canada has done. Is that something that we should borrow? But more importantly, if you're in a situation like those things I've described, like the stories we've just been telling today, if you find yourself in that situation, do you think you need to do something? Yeah, please don't hesitate. Don't wait until death comes and things are haywire. Don't wait until things go south and you're at a loss and now all these things become your reality. Please don't wait. Thank you so much. Bye.